So merci. Good morning, class.
Good morning, teacher.
Okay, now we take attendance first. Stop talking. Okay. Meng Celes Chuah. Chong
Yeah.
Hey, no manners, Joyce. Pay attention. Okay. In today's class, we will talk about Judicial Precedent. Do you guys know what is it about?
I don't know.
In this video, we will be discussing about whether the decisions made by the more senior courts have to be accepted by the more junior courts, or else the law will become anarchic and loses in coherence, clarity, and predictability. Before diving into the main discussion, it is vital to understand the structure of the courts. The United Kingdom has a hierarchy of courts. First of all, at the bottom of the courts will be the magistrate courts and the county courts. They are inferior courts that are neither binding nor persuasive. Besides, another inferior court will be the Crown Court. Crown Court listens to criminal cases, while the magistrate courts listen to the less serious one. The decisions made in the Crown Court are usually persuasive and worthy of being used in the argument, especially those made by High Court judges sitting in the Crown Court. Unlike the other two, county courts listen to civil cases. Above them are the superior courts, the Supreme Court followed by the Court of Appeal and the High Court. In the High Courts, their decisions are binding to the inferior courts but not other high courts. In the Court of Appeal, their decisions will be binding to the High Court and the lower courts as well. They listen to appeals from the Crown Court, High Court, tribunals, and certain cases from the county courts. Lastly will be the Supreme Court, which was replaced by the House of Lords by the Constitutional Reform Act 2005. The Supreme Court is the final court of appeal for all UK civil cases and criminal cases from England, Wales, and Northern Ireland. They hear appeals on arguable points of law of general public and constitutional importance. It helps to maintain and develop the role of the highest court in the United Kingdom as a leader in the common law world. Their decisions are final and have to be binding to all the courts.
Looking at the fact, I have concluded that it is more satisfactory if the rule is absolute. Judges of any court should not follow the decision of Privy Council if it is inconsistent with the decision of Superior Court.
However, the Supreme Court also held that it should be possible for the Privy Council itself to rule that the Supreme Court and the Court of Appeal was wrong, and so that the decision of the Privy Council should be followed. Another issue that arose was related to the relationship of the Privy Council and the Supreme Court. It is held that there is no doubt for a court to follow the decisions of the Privy Council unless there is a decision made by the Superior Courts contrary to it, but it is not bound to the President to do so.
Judicial precedent refers to the source of law where past decision of the judges create the law for the future judges to follow. The doctrine of judicial precedent involves the application of the principle of stare decisis, which is translated into stand by what has been decided and do not unsettle the established. In practice, it means that inferior courts are bound to apply the legal principles set down by the superior courts in the earlier cases. A binding precedent is only created when the facts of the second case are sufficiently similar to the original case, and the decision was made by a court which is senior to, or in some cases, the same level as the court. For example, in the case of Khew and Stevenson, the court sets a binding precedent which was followed by Grant and Australian 19 years, where the manufacturer owed the duty of care to the ultimate consumer.
I would like to establish the neighbor principle, which the defendant would owe a duty of care to the end consumer. Hence, I will rule that the claimant claim is successful.
In this case, I would like to apply Khew and Stevenson's neighbors principle. Hence, I will allow the claimant's claim.
In addition, the judgment in Shaw and DPP also sets a binding precedent where the House of Lords held that a crime of conspiracy to corrupt public morals exists, which was then set as a binding precedent in the ruler and to make the judicial precedent work, it is necessary to know the legal reason for past decision. Therefore, at the end of the case, there will be a judgment where a speech will be made by judges giving the decision and the reason behind it which amount to ratio decidendi. The ratio decidendi forms a legal principle which is a binding precedent. Sir Rupert Cross defined the ratio decidendi as any rule expressly or impliedly stated by the judge as a necessary step in reaching his conclusion. The remainder of the judgment is called obiter dicta, and judges in future does not have to follow it. Ratio decidendi is said to inform a binding precedent, but obiter dicta is only persuasive precedent. In addition to binding precedent, there is also persuasive precedent where this is a precedent that is not binding on the court, but the judge may consider it and decide that it is a correct principle, so he is persuaded that he should follow it. For instance, this happened in the case of Attorney General for Joyce and Holly, where the majority of the Privy Council ruled that, in the defense of provocation, a defendant is said to be judged by the standard of a person having ordinary power of self-control. This was contrary to an earlier judgment of the House of Lords. Although a decision by the Privy Council is not binding on the English court, in R. and Muhammad, the Court of Appeal followed Holly rather than the decision in Khew. Then, in R. and James and R. and Curry, the Court of Appeal confirmed that the decision in Holly should be followed by courts in England and Wales.
As mentioned above, Supreme Court decisions are binding on all lower courts. House of Lords was self-binding under the case of London Tramways, which House of Lords held that the certainty of law is more important than individual hardship. In the past, the only way to change past decisions is by passing an Act of Parliament. However, Lord Gardiner issued the Practice Statement 1966, which allowed it to depart from its own past decision when it appeared right to do so. Even if House of Lords is allowed to do so, but they were reluctant to use it, as seen in Nagar against DPP, which refused to overrule the case of Shaw against DPP. The first case involving the use of Practice Statement 1966 was in Conway against Rimmer for the Civil Division, while Criminal Division R against Shiftbury. The statement of Lord Neuberger above has been challenged by the Court of Appeal in two cases. Firstly, Broom against Kessler, which didn't follow the House of Lords decision in Brooks against Barnett, and Melangos against George Frank case, which Havana Railways was not followed. In Melangos' case, House of Lords pointed out that Court of Appeal had no right to ignore or overrule the decision of House of Lords. This has affirmed the statement in question, which states that senior court decision must be followed by lower court. Court of Appeal is usually bound by its own previous decision and the decision of House of Lords and European Court of Justice, except in a few situations laid down in Yar against British Aeroplane. First, where the previous decision of Court of Appeal conflicts with the decision of House of Lords, then House of Lords decision should prevail. This can be seen in the case of Family Housing Association against Joyce. Then, second one, the previous decision of Court of Appeal conflicts, then the judges can choose from one of those. For example, in the case of Starmark against CPL. Court of Appeal can also depart from its previous decision when the decision made was per incuriam, like in the case of William against Fawcett. Per incuriam here means the decision was made without proper care. However, in criminal division, there was a greater flexibility as seen in the case of R against Root. Hence, it can be said that House of Lords has a very high flexibility in departing from previous decision, provided it appears right to do so, while Court of Appeal can only do so when there is an exception, seen in Young against British Aeroplane.
Under the doctrine of binding precedent, it is significant for the judges to follow the previous decision when dealing with cases concerning facts that are similar to the previous cases. Nevertheless, under certain circumstances, the judges can avoid having to follow the precedents in several ways. The main ways to avoid precedents are distinguishing, overruling, and reversing. Let us first look at the distinguishing. If a court may find sufficient differences between the material facts of a previous and current case, then it can avoid following the precedent and may depart from the previous decision. The process of distinguishing is extremely important because it enables the judges to develop the law rather than being bound by precedent in every situation. In fact, there is a precedent for every single topic of law, and the judge wish to distinguish a case will have to find small differences in order to not be bound by precedent. We should also note that distinguishing does not affect the validity of the precedent of the previous case. Let's look at the example cases. The two cases demonstrate the process of distinguishing is Balfour and Balfour and Married and Married. Both cases involve a wife making a claim against her husband for breach of contract. In the case of Balfour and Balfour, husband and wife lived together happily and had verbal agreement. The court held that the agreement was merely a social and domestic agreement which does not amount to a contract. In the case of Married and Married, husband and wife had a written agreement after they separated. The court distinguished this case from Balfour and Balfour and stated that spouses who have separated generally have the intention to create legally binding contract. Next, let's look at the overruling. A court higher in the hierarchy may decide not to follow the existing precedent set in the lower court and may change it or blank it. The court is viewing the validity of a precedent previously and overruling may occur if the court finds the legal rules of the previous case was wrongly decided. This creates a new precedent binding the lower court. For example, the Court of Appeal can overrule an earlier High Court decision. In comparison with the mechanism of distinguishing, overruling is rarely used. Overruling can be seen in the case of Murphy, which overruled Ann's case.
I could see proximity in this case. Therefore, I allow claimant's claim to recover loss suffered due to the defective product.
In this case, I will not follow the judgment in the case of Anne and Merton because it will definitely open up an exceedingly wide field of claims. Hence, I rule that the defendant is not liable.
In the case of Anne and Merton, the court held that the defect was viewed as a damage, so it can be recoverable. However, in a more recent case, Murphy and Brentwood, the court held that the damage suffered by the plaintiff was neither material nor physical, but purely economic. However, pure economic loss can never be recoverable. This decision has therefore overruled the previous decision in the Ann's case.
Thirdly, precedent may also be avoided by reversing. A superior court may overturn the decision of a lower court on appeal in the same case. For instance, Court of Appeal has made a decision in a particular case. The Supreme Court then forms the opposite conclusion in the following appeal in that case. In the case of Sweet and Parsley, is one of the examples of the reversing cases. In this case, the defendant was convicted of managing premises for cannabis. Court of Appeal held it was a drug offense and her lack of knowledge was irrelevant. However, when it comes to the House of Lords, the court disagreed and reversed the decision, stating that she required knowledge and was not guilty. To emphasize, if the court is unable to avoid binding precedent through these three ways mentioned above, they will have to follow the precedent.
The advantage of precedent system is that it is convenient and time-saving as inferior courts have guidelines to follow. Therefore, judges do not need to do too much work and look at the minor details. Another advantage is that its certainty and predictability can be applied in the law as the outcomes of the cases are similar to the previous cases. This allows lawyers to advise their clients as to the likely outcome of the litigation. For example, in the case of London Townsway, the practice statement 1966 and the reason why Lord Canning proceeded made failure. Besides, the use of previous precedent satisfies the requirements of justice and provide fairness as people are treated alike in similar circumstances. However, there are ways for precedent to be avoided, so there is an element of flexibility too, where judges can distinguish case on their facts. Hence, it also means that the bad decision can be remedied. It is unconstitutional because it allows judges to change the law and violate the rule of separation of power. In addition, the law can be applied in a practical, wrong manner because the law has already occurred. On the other hand, there are serious disadvantages. Firstly, the advantages of saving time is the disadvantage that judges may start giving judgment mechanically without giving their minds to be a possible judgment to the cases. The advantage of certainty is creating a condition of uncertainty increasingly by the ability of judiciary to select which authority to follow. These circumstances get some criticism from a lot of commentators such as James Gerjean has highlighted the element of uncertainty and the editor of Angro. The leading practitioner said that there is a lack of practical experience of some judges. Furthermore, another major disadvantage is the operation of the doctrine of binding precedent. It depends on the existence of an extensive reporting service to provide access to judicial decisions. Precedent may have retrospective effect and promote laziness as the only thing that judges need to do were to same the previous cases with same facts and give the same decisions. Precedent is also rigid as bad judicial decision may be perpetrated. To further illustrate, there is only a position in a house of law to give an ultimate ruling on the issue before the court, and it's extremely expensive and time-consuming to get a case.
Okay class, after watching this video, what are your opinions?
Miss,
Yes?
in my opinion, I think judicial precedent enables the parties to predict possible outcome of the cases, and they can decide whether they want to sue or not.
Good.
I agree with Joyce's opinion. I think the doctrine of binding judicial precedent is a vital element in the English legal system as it provides certainty and creates fairness in the judgment.
Miss, if the lower court is not following the higher court, then every court has their own discretion and the law will be very unorganized.
True.
Miss, I do agree with your opinion. I think that because the lower court shouldn't be followed with the higher court, because the decision in per incuria will apply in other cases indefinitely.
Well done class. Now I'll do the conclusion. In conclusion, the judicial precedent brings equally advantages and disadvantages to the English legal system. As mentioned in the case of London Tramways, the House of Lords held that certainty was the most important in law, although there will be possibilities that unfair decisions will be made. However, these decisions are made by the professionals and there are still ways to avoid the judicial precedent. Hence, it will be more satisfactory if we follow the doctrine of judicial precedent but at the same time be more flexible.